continue with our 9 o'clock call. I do want to note for our Zoom participants that the matter of the estate of Helen Sproseg has been already called, and I have authorized that estate. Mr. Mark Welsh, your brother was here with Mr. Lucas, and I apologize for not making sure you were able to participate in that. But that has been authorized, and you should expect to see progress in that estate very soon, I'm sure. I do want to take the time to tell you, I'm sorry for your loss.
Thank you.
All right, so you're welcome to log off then. If you're here in the matter of Sproseg, that one is complete.
Thank you. Have a good day, Your Honor.
You're welcome, you too. All right, I'm gonna be ready for the next one.
We are on the record in the matter of Herbert Betts, file number 25053686.
Court's been asked to authorize a probate estate. May I have the names of our participants, please?
Good morning, Your Honor. Good morning to your staff. Robert Gross, P82012, appearing on behalf of the petitioner, Mrs. Susan Rogers.
Very good. Do you have Ms. Rogers with you?
I believe she is muted.
Is she, do you recognize her under Sue's S24?
Yes.
Okay. All right. So Ms. Susan Rogers, you've just been invited to unmute.
Okay, can you hear me now?
Yes. Would you give us your name for the record, please?
Susan Rogers.
Thank you. Welcome. All right, Mr. Gross, any presentation today?
Your Honor, I would rely on the petition that we submitted and ask that the court grant that. I don't think there's anything that needs to be addressed orally. Be happy to answer any questions.
Very good. What are the proposed assets of the estate?
There are, and we attached, I believe, there's a home in Manatee Beach, and there are some bank accounts. There's a Wells Fargo account in particular.
All right. Is there a number of assets in the estate to the extent that a bond should be considered, in your opinion?
I don't believe so, Your Honor. I don't think a bond's necessary.
Have you had any opposition to your proposed administration or findings of errors or anything else that you've requested?
Not that I've heard of.
Very well. All right. Well, the court finds all interested parties were given notice. That does include publication. There is. Excuse me.
I'm his son.
Oh, okay.
I'm
Mr.
here to
Betts' son.
oppose.
All right. Come on up to our council table, please, and give us your name for the record.
My name's Brian Betts.
All right. Welcome. There is a will that's been proposed. Do you have copies of the documents that were prepared and submitted for today?
Yes, Your Honor.
Very well. So you're familiar then with the will that has been submitted and requested to be part of the administration of the estate?
Yes, ma'am.
All right. That does appear to have been signed. Are you, so tell me a little bit more about what brings you in today.
Well, the house that they were mentioning is my house. It's not my father's house. He has a house in North Carolina and a house in Florida. The house that I have, I purchased on my own in 2005 and then paid for. The will that we have, the one that I received, says that they could not find the will, and it's a copy. There's edits to the will. There's no initials. There's no dates. There's no signature that I have. I believe that also states that Mrs. Rogers can't be held accountable for any loss or anything that occurs during this. I don't find that to be a good thing.
I see. Would you like to respond to that, Mr. Gross? I do see what he's talking about. It does appear to have on page 3 some edits which cross him out of the will. and several other people. And then, of course, on the last page, there is no date, and it says /S/ under where Herbert Betts' signature would be. There's no date nor any indication of verification by witnesses.
Your Honor, and I recognize that as well. Submitting this is the best that we have. It's what we believe was prepared and what stands as the intended will. I suppose in the alternative, we would ask that the court find that that he died intestate, but he's married. The proposed personal representative is the best friend of his wife, and that would still make her an appropriate personal representative.
The proposed personal representative is the friend of his wife.
Yes.
Yes.
Is that what you said, Mr. Gross? Okay, so that person would not necessarily have priority under the statutes, as it would not be a relative.
I understand, and it could then be his wife who would then delegate those duties, but he is married, and so I guess in the alternative, we would ask that his wife be appointed, but relying on the document that was submitted, I mean, I think it's very clear of his intent. It is someone known to him and his wife. And again, that's what we are submitting is the best information and documentation that we have.
All right. Okay, Mr. Betts. Well, it looks like the pleadings themselves, amended on record, would mean that what he's asking me to do is allow the estate to be opened and not use this will. Would that be satisfactory to you?
My belief for me is that my father died and he was married, that his wife should get, if there's no will and they can't seem to find
Well,
one.
that's what I'm asking you.
Yes.
If he wants to open the estate, understanding that the will not govern the administration, do you have an opposition to that? Do you have an objection to that?
No.
Okay, all right. So under the statute, as Mr. Gross indicated, Ms. Marguerite Betts would be the person who would be first entitled to serve as personal representative. She's requested her friend Susan Rogers do that for her. Do you object to that? Or would you prefer that we ask Ms. Marguerite Betts to do it?
I would prefer that my stepmom took care of her stuff, and if she wanted assistance from a friend to help her do things, that's fine, but I don't think that it should be legal that Susan Rogers would be able to do with what she wants with, I believe it says without bond.
Okay.
I want to make sure my stepmom gets what she's supposed to and not.
All right, so Mr. Gross, you did suggest that perhaps Marguerite Betts would be willing to serve as a personal representative and would have obviously priority in that capacity. Is that in fact what you would like to accept as a proposal to your initial request, or what is your
I
position?
think maybe in the alternative, we would ask that Susan be appointed, and then if the court, and I understand that there's a concern here with a bond being posted, then we would just say that Susan still be appointed with a bond and a minimum.
Mr. Gross, I really would hesitate to allow just a friend of the family to serve in this capacity when we do have family members that would have the right and really the responsibility in many ways of administering the estate. If you'd like to move forward to show that, so Ms. Marguerite Betts does not want to, if she doesn't want to do it, then perhaps you could ask Mr. Betts or Ms. Tracy Betts. It looks like there's an Herbert Betts as well. All of those
He has
people.
brothers and sisters also.
Please don't interrupt. I'm sorry. Thank you. All of those people would have priority before Ms. Susan Rogers.
I
And I would
understood,
request
Your
that you
Honor.
would-
Then I guess we would just ask that Marguerite be appointed.
All right. Any further objections then, Mr. Betts, to opening the estate, recognizing it as not being directed by a will? So in other words, it's intestate, legally speaking, and then Marguerite Betts being appointed the personal representative to
No.
direct the administration. All right. I do find that that's appropriate. The other issues that Mr. Betts is raising today has a lot to do with the administration itself. And so if there's an issue with the title on your property or something like that, you'll have to work with Mr. Gross and with Marguerite Betts in order to see if you can resolve that. And then, of course, I'm available to you in the event that there's a contest or disagreement about how those assets should be administered under the statute. Does that make sense?
Yes.
Okay. And I would always encourage and welcome you to seek your own independent legal counsel if you have any questions as well. All right. So I do have the death certificate that establishes that Mr. Herbert Betts did pass away April 1st, 2025, a resident of Lenawee, making venue appropriate in Lenawee County. The heirs are determined and uncontested. I am making the finding that there is an intestate estate present here for the issues that were explored on record today. I am also denying the appointment of Ms. Susan Rogers, also known as Susan Shaw, and appointing Marguerite Betts, who would otherwise have the first and best priority under the statute. And the order reflects that. As a result of those findings, I am not going to issue the requirement that a bond be taken in this case, but I'll leave that to the parties, and if they need to come back later to review that, I will be available. So the order will need to be modified slightly, as well the letters of authority. And so as soon as those are completed, we'll get those out so that everyone can start working through those estate assets. And I do want to take a moment to say I'm very sorry for your loss. Any other questions?
No, Your Honor.
All right, thank you. That's all for today. Okay, all right, so as soon as they get the corrected documents around, I'm sure they'll send you copies. You're all set for today.
I went through probate with my mother's estate, and that was just recently done. I don't know if that was through here, but that's where the house came into play. It had nothing to do with this. So I don't.
That's really not before me today. I wish you the best of luck in navigating that. As I said before, you may want to seek counsel on some of those issues, because I don't have any of that in front of me to look at or review for you today, okay?
All right, thank you.
You're welcome. Have a good day.
You did.
Thanks. Okay, let's go on to our next one. Whenever you're ready.
Okay, we are on the record in the matter of Thomas Wasnia, on number 76032-736.
All right, court's been asked to approve the 45th, 46th, and 47th annual accounting in this case, submitted by Mr. James Nicholson. Do we have Mr. Nicholson here today?
Here, Your Honor.
Very good, welcome.
Michael McFarland, Attorney Guardian ad litem. I have submitted a waiver and consent, Your Honor.
Thank you. Yes, I do have reflected in the file the 45th, 46th, and now the 47th waiver, which is great news. Deputy Ames, would you swear in Mr. Nicholson, please?
Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Feel free to sit down if you want to.
All right, Mr. Nicholson, do you, you are the author of the accountings in this file?
Yes,
Very good. Is the information contained in those truthful, accurate, and complete to the best of your knowledge and information?
it is.
Very good. Is there anything you'd like to say about the work in this file?
No,
And how is Thomas doing?
he's not doing well. He's in Toledo Hospital right now. He had a fall. He lives at Coleman Foundation in Hudson, and he had a fall late Sunday night, Monday night, and they thought he had a minor heart attack. They ruled that out, but they're evaluating other problems that he had. So we were there all day yesterday, and we're going down today to see how he's doing.
Very well. Well, thank you for taking the time out to come to the court hearing today. And I wish you and Thomas both the best of luck.
Okay, thank you.
The accountings do appear to be accurate. Mr. McFarland has reviewed those as well. And it is the order of the court that those accountings have been allowed. I've signed that order for you. You're welcome to step across the hall for a copy before you leave today. Safe travels, and again, best of luck to you.
Thank you.
All right. All right. Whenever you're ready on the next.
We're on the record in the matter of Zachary Welde, file number 23052-662.
All right, the court's been asked to approve the second annual accounting in this file, submitted by Mr. Richard Welde. Do we have Mr. Welde with us? I don't see anybody in the courtroom.
He is not appearing today. I am here on his behalf. Lindsay Artis, P81858.
All right, thank you, Ms. Artis, for coming this morning. As you probably just saw, I typically like to have the accountings verified by our fiduciaries under oath. Would you be able to do any presentation on his behalf then today?
Yes, I am ready and able to answer all questions that the court may have and can give a presentation. I don't know if you want me sworn in. I am an officer of the court, but some courts still like to have me sworn in.
I don't typically do that, understanding that as an officer of the court, you already have some obligations that are higher than the average member of the public. I would like to hear a little bit about what's happening with the file, though, whenever you're ready.
Yes, Your Honor. So we have submitted the second annual account for the Supplemental Needs Trust on behalf for the benefit of Zachary Welde. The trust itself is performing very well. A large majority of the assets are invested, and we had great returns this year. The family is still not really accessing the funds. They're reserving them for potential future needs given his medical condition and diagnoses. The expenses that were incurred include legal fees, legal fees, CPA fees, and then federal and state tax payments that were due based on the interest earned. All interested parties have been served. No objections have been received. We did mail in that proof of service along with a proposed order. We are requesting that you approve legal fees incurred within the last accounting period. They're reasonable and necessary, and we believe they ought to be allowed. With that, I see no reason why it cannot be granted. If there's any additional questions that the court may have, I'd be happy to answer them.
Yes, so the law distinguishes between attorney fee rates and fiduciary rates. In the capacity of trustee, have you done any research or have anything to speak to as it relates to the difference, if any, on your services as an attorney versus the trustee?
So our office does not serve as the trustee. Richard Welde is the trustee. So our services are exclusively legal. I do know that my firm has conducted multiple studies multiple times to ensure that we're within the acceptable range of services provided throughout the state. I believe that we are not at the top nor the very bottom. We fall somewhere in the middle.
Well, any other trustee would have had to have prepared the accounting on his or her own and been paid the usual rate of $35 an hour through the court, or authorized only as a fiduciary in that amount typically. Is there a reason that I should be allowing attorney fee rates for preparation of otherwise typically fiduciary obligations?
I apologize, Your Honor. I've never been presented with that specific question. I guess that we are using our legal expertise, background, and knowledge to prepare the proper forms, get them filed, make sure everything is compliant with the rules of the state of Michigan. This is something that the client has hired us to do on his behalf, and therefore we do charge a legal rate versus a fiduciary rate.
All right. It looks like the accounting spreadsheet, the first annual account in the petition to allow was billed at $355 an hour. Is that accurate?
Yes, that is correct.
Everything else looks like pretty standard legal obligations. That is over $300 more per hour than I would have allowed a typical fiduciary. I'd be willing to adjust that down to perhaps a 185, which I've seen I have allowed in other cases in Lenawee. And I see too, drafting of the petition and account proof of service was billed for 1 hour at $185, lower down. So I'm not sure what the discrepancy is on the accounting versus the petition. It appears that the accounting work was charged at a higher rate even than your legal rate. Is that accurate?
No, so there is an attorney rate and a paralegal rate provided within this work. So I'm wondering, and I'm sorry, I'm trying to look at the bill right now, but if what you're seeing that 1 hour at 185 was service of all the pleadings, not actual drafting of the legal documents, but drafting of.
It says petition and account, prepared proof of service, drafted proposed order, filed proof of service, and proposed order with Lenawee County Probate Court. 1 hour, $185 on June 13th, 2024. It does appear to have a PL next to it, indicating perhaps paralegal rather than an attorney.
And so, yeah, I believe that drafting is preparing the orders, the proof of service, letters to the interested parties.
At a paralegal rate.
Yes.
That's typically the rate that I would approve for purposes of attorney fees in Lenawee.
Okay.
I do understand that this is a trust rather than a conservatorship, so I can recognize a difference there, as well as the trustees' right to really decide who is going to be doing this work. I also appreciate that the accounting does reflect, as you indicated on record, that the funds are largely untouched, with the exception of, it does look like some of the attorney fees, clearly, and the federal and state tax payments. I see also there's a CPA fee, and that's for the taxes, I'm assuming?
Yeah, to prepare the tax returns.
All right. Well, I'm going to allow it today, but I would request that you, number one, have your client here with us next time to verify that he's reviewed the work as well, and that he in fact has been the person to request services at that rate. And I would ask you also to have a look and make sure that what the rates are under the circumstances are consistent with what we've seen in the last few years on the case law and the guidance on those rates.
Okay, I definitely will be taking that back to my office, Your Honor, because we have several files in front of you. So I'm sorry I was not prepared for that argument or position today, but that is definitely something I will relay to our entire team.
I appreciate it. All right, you have a good day then. I have approved the accounting and with the requested attorney fees. Unless there's any questions, that's all for today.
No, thank you so much, Your Honor.
You're welcome. That's it for our 9 o'clock call.
Take care.